Lasker here. Minister, you're very welcome into the channel this afternoon. This is a really important piece of legislation, and it's one I will be very much welcoming. I'll just deal with a couple of issues before I get on to your own speech. So by amending the Social Welfare Acts to exclude the assessment of child maintenance payments from the social welfare means test, the bill can potentially alleviate financial burdens on custodial parents and ensure that children's welfare is not affected by such assessments. The repeal of provisions relating to liable relatives can simplify the social welfare system, removing complexities associated with holding relatives financially responsible for social welfare payments. The bill makes provisions for individuals granted permission to reside in the state under Section 66 of the International Protection Act 2015, potentially offering supports and assistance to this specific group of individuals aligning with humanitarian and immigration consideration. This bill includes provisions for the short title construction and commencement, which can provide clarity and guidance on the application and interpretation of the amended provisions, thereby promoting legal certainty and consistency, especially in relation to the International Protection Act 2025. So this is very much a long-awaited legislation for custodian parents, and I very much welcome it. The bill references the provision of certain matters relating to the individual granted permission to reside under the International Protection Act 2015, but without specific details, the potential impacts and practical implications of these provisions remain unclear. The proposed changes to the International Protection Act 2015 would disqualify certain individuals from receiving assistance specified in Section 139(1) of the Principal Act if they are resident in a designated accommodation centre. These changes will also amend Section 60 of the International Protection Act 2015 to include the definition of a designated accommodation centre and specify the entitlements of individuals with valid permission to reside in the state. There are concerns about accountability and implementation. The repeal of provisions relating to liable relatives may raise concerns about accountability for financial responsibilities within families, potential shifting the burden onto social welfare systems and raising questions about equity and fairness. The bill's impact on the broader legal and policy framework, including implications for family law, child support and immigration policies, need to be considered. Individuals with permission to reside in the state will be disqualified from certain social welfare benefits if they are resident in these accommodation centres. These implications may affect taxpayers, as they may bear the burden of additional costs associated with providing medical care and supplementary welfare allowances to individuals who have been disqualified from certain benefits. These changes to the International Protection Act may lead to a shift in the allocation of resources and funds within the social welfare system, which could impact taxpayers who fund these services through their contributions. Overall, the changes to the International Protection Act 2015 may have implications for taxpayers in terms of allocation of funds and resources within the social welfare system and the potential additional costs associated with aiding individuals who have been disqualified from certain benefits. There are some potential ways in which these changes could be abused by individuals living in designated accommodation centres. There may be individuals who falsely declare that their resident status to continue to receive benefits despite residing in designated accommodation centres. Without proper checks and monitoring, some individuals may attempt to exploit any loopholes. Individuals could potentially claim to have dual residency, providing false information about their living situation to continue receiving benefits from both the designated accommodation centre and other sources. There's a possibility of collusion between individuals residing in designated accommodation centres and external parties where false information is provided to maintain eligibility for benefits. There may also be legal loopholes or ambiguities in the legislation that could be exploited by individuals or groups seeking to continue benefiting from the social welfare system despite the intended disqualifications outlined in the proposed changes. These changes could potentially place added strain on the Department of Social Protection staff within the designated accommodation centre areas and related support welfares like the Citizens Advice boards that are Citizens Advice centres that are around the various areas. The reductions in financial assistance may drive increased demand for assistance in other forms, including the supplementary welfare allowance, and further stretching the available resources. While I welcome the degrees, I wonder has an assessment been done in relation to HR and the cost of this. So it's essential that we have robust monitoring and enforcement mechanisms in place. Clear guidance and procedures for assessing residency and eligibility for benefits needs to be established, and consistency applied to prevent any potential abuses of the system. So, Minister, in relation to your speech this afternoon, just a couple of things. I'm very disappointed in relation to the Child Maintenance Agency that has not progressed in any way. I think that would have been an important agency for custodian parents, and it just seems to have been sidelined there because they couldn't reach a consensus, which is a great shame. So I might take that matter up with the Minister for Justice. I welcome the announcement this morning of the child benefit scheme and that being actually brought forward to May instead of September. I don't know why you announced these carrots in October in your budget and hold them dangling there in front of parents when they could be implemented a little bit sooner. But I welcome that, and I'm sure there's many parents with school-going children in secondary education who have turned 18 that will be able to avail of that. Minister, I want to digress for a minute, and I hope you might be able to help me. There was an issue that I know that you met this afternoon with some people from the Irish Deaf Society in relation to the voucher scheme for the sign language. I don't know whether it was you that met them or whether it was somebody from your department. But if you could update me, if you have an update, I know. Social welfare bill now.
If you want to put on a commencement or something to talk to the minister about another issue,
it is social welfare.
I know what the brief is.
And I respectfully ask, and maybe
here.
the minister would kindly answer that. You know, it's such an important service for our deaf community, and maybe you could update me on that to see. It's awful pity that that's going to be taken away on the 20th of February for those very vulnerable people in our society.
Thank you, Senator.
Thank you.
Can I just thank all the senators for their contributions. Senator Burke, Senator Keogan, Senator Arda, Senator Wall, Senator Boyan and Senator Dolan. Now, as I said, I'm very pleased to bring forward this legislation, and I know that you have raised a number of issues with me, so I think I'll just go straight to dealing with the issues that you raised. I said earlier a new weekly payment of €38.80 per adult and €29.80 per child is being introduced for the beneficiaries of the Temporary Protection Directive, and this will be administered by my department. And these changes are designed to ensure the sustainability of our system. They will also align us more closely with other EU member states, and we will of course continue to meet our obligations under the Temporary Protection Directive. Where a beneficiary of temporary protection is not resident in a designated accommodation centre, he or she will be eligible for social assistance payments on the same basis as Irish citizens. So I think that's fair enough. And it's important to note too that beneficiaries of temporary protection, whether resident in a designated centre or not, will continue to have full access to the labour market. Just going back to the child maintenance, can I just say where a person is getting a child maintenance payment, it just means now this new law, it won't be assessed against their income, so they'll be allowed to get the maintenance for the child and it won't be assessed for social welfare purposes. Just to say also that the payment was the payment will be, the question was raised here about the beneficiaries of the Temporary Protection Directive. The payment is in lieu of a social welfare payment and be made to all residents in designated accommodation centres. They'll have, the people that come here will have access to state accommodation. They'll also have access to children's allowance. Or child benefit, I keep calling it that old name. They'll be entitled to receive child benefit and additional needs and urgent needs payments in circumstances where they meet the eligibility criteria for these payments. And beneficiaries receiving the weekly allowance will be entitled to work, and the Public Employment Service will actively engage with them. So what we're doing here is bringing us further in line with all the other EU countries. the other is...
Sorry, point of order, is it?
Point of order. Just on that, Minister, could you confirm the people that are currently...
Point of order.
Or is it something that you
Question,
said?
your point of order is based upon what now?
Based on what Minister has just stated. I just wanted clarification on something. Is that okay? Can I get clarification?
No, you can't get clarification. It's not a point of order.
That's fine.
It's not a point of order.
That's fine.
Sorry.
Okay.
That's all right. Sorry, Minister.
There's the issue around liable relatives was raised also, and can I just say that these changes will simplify the system for the people involved. It does not negate their responsibility as parents to provide for their children, but it just means that we'll not have to have the liable relatives. The liable relatives was a case where one parent was receiving full state assistance in terms of maybe the one parent family payment or whatever, and the state felt obliged to try and get that money back from the other parent. And given that we're paying out 614 million in one parent or in that type of assistance, and we're only pulling back 400,000, it seemed to be a rather futile exercise. And it was torturing. It was torturing everybody, so we decided it was best just to remove that. The Child Maintenance Agency, it was mentioned there about establishing a Child Maintenance Agency. Minister McEntee has announced significant reforms to make the family court systems more accessible and family friendly, and I think we need to see how those reforms bed in. As part of these reforms, the Department of Justice undertook a review of enforcement of child maintenance orders, and that's the trick here, enforcing child maintenance orders, and how we're going to, if you have to pay them, just get on with it and pay them. Minister McEntee published that report, and it contains 26 recommendations, including measures that look at how we can strengthen enforcement of child maintenance payments via attachment orders, and I'd love to see attachment orders going all the way so that there's no, it's such a waste of everybody's time in and out of court trying to get maintenance payments. If you had a good strong attachment order, this is my view, and that it's deducted at source. I think that's the way to go here. But look, it does take a bit of work. It's not quite as simple maybe as it sounds, and I know that Minister McEntee will progress these proposals in the 26 recommendations that were announced as quickly as possible. Also, Senator Wall mentioned about the foster carers getting a state pension. Can I just say that matters related to foster caring, they're actually and the associated payment are actually the responsibility for the Minister for Children, Equality, Disability, Integration and Youth, and for TUSLA. And the government acknowledges the important role that carers, including foster carers, play, and we are fully committed to supporting them in that role. The current state pension system provides measures including PRSI credits, homemaking disregards and home caring periods to recognise caring periods of up to 20 years outside of paid employment in the calculation of a payment rate. Foster carers are entitled to the benefits of the homemaker scheme for home caring periods, and they may also be entitled to long-term carers contributions where they meet the criteria and the 20-year threshold. Officials in the department have recently met with foster care representatives and provided detailed explanations on the state pension system and related contributions and the options actually open to them. And just finally, there was a question about the Irish Sign Language Scheme. I know it's not part of this bill, but just to say that my officials today, I wasn't aware of this until late last week, and my officials today met with representatives from the Citizens Information Board and the Irish deaf community. And look, I haven't heard the outcome. The meeting could still be going on for I don't know. I haven't heard the outcome, wasn't talking to them, but I will be getting a report on it. I did support them very much in these voucher schemes. I met with them last year, but it's important too that when it comes to public money that we have full transparency and accountability as well. So look, I hope there's a solution here, and I'll certainly be working towards it. So.
Thank you.